Hi, I'm Commissioner Raquel Regalado. Thank you for joining us on your lunch break. Today, we're talking with one of our amazing community partners about the different programming and opportunities that we have and how we work with them and how we can work with you to do more and provide these services to all the residents of Miami-Dade County.
I'm Cassio Marquez. I'm the Condominium Ombudsman. Today we're going to dive into condominium rights and responsibilities of unit owners themselves.
Thank you. And
So,
I'll just say
yeah,
we are recording, so this will be available just like all other webinars on the commissioner's um, YouTube. And I'll also share a e-blast thanking everybody for registering and any information Cassio shares with us today. Awesome. It's
yeah,
all yours.
thanks. Before we get started on the unit owner's rights and responsibilities, we like to cover um, the division's jurisdiction and what the division, as far as the compliance office, can assist you guys with. There's two different jurisdictionals depending on if your condominium is a residential condominium or if you're still under developer control itself. So, under developer control, this is prior to your condominium turnover. The division can investigate allegations and enforce compliance relating to the development, the construction, the sale, the lease, the ownership, the operation, and the management of that condominium itself. Now, after the condominium has been turned over, jurisdiction gets a little bit tighter in what we can and can't do. But what we can do related to our jurisdiction relates to the records access. So you have a right to access records, let it be financial, rosters, anything like that. You have a right to access those records. If you're not provided access, the division can open an investigation for that. We also have election issues, procedural completion of elections themselves. This includes voting requirements, recalls, electronic voting, elections during emergencies. We also have, once again, as I said, the maintenance of records, not only financial records, but we also have maintenance of records the association has to maintain, which does also include websites. So, associations that are over 25 units now have to maintain a website. So, there's specific records that have to be on there. If they're not on there, that is something we can help you out with and see if we can get a complaint open for that investigation. Procedural completion of the structural integrity reserve study. So we do have procedural completion of the SIRS and also the milestone report. And also we have compliance that they do the required repairs when it's related to the milestone. So required repairs related to the milestone. But we also have the procedures of them completing the milestone and the SIRS report. In addition, we have the reporting of the SIRS themselves. So you do have to report that you completed your SIRS, and that is reported to us and also reported to unit owners themselves. So if they haven't done that, that is a potential violation we can take a look at. The procedural aspects of meetings, we'll talk more about that and what's allowed at a meeting, what's not allowed at a meeting, what's your rights at meetings, to see if they are, you know, conflicting there. Disclosures of conflict of interest. You can have conflict of interest in condominiums, but it has to be disclosed. Removal of board members and officers. The requirement for the association to maintain fidelity bonding insurance over the monies. So we do have jurisdictions over insurance over the monies. Any written inquiries that unit owners make to the association. So that's how you ask the association questions you would like them to answer. And then lastly is the new education requirements that board members have to do. And we'll talk more about that, I believe, in here. So let's start off here with rights of the condominium unit owner. So first thing, the first right you have, right, is the right to attend meetings. Board meetings are open to
I'm
any
sorry.
owner in the
I'm sorry,
community. So,
Cassio.
yeah.
Sorry
Uh-huh.
for interrupting. Will you be showing us a presentation?
Oh, yeah, sorry, I wasn't. I'm over here. Just it says stop sharing. I thought I was sharing it.
Also, if you
Is it
wouldn't
popping
mind,
up now?
I can see it now.
Okay,
If you
perfect.
don't
Yeah,
mind, for those that don't know who the DBPR is, could you give us a high overview of who you are?
yeah. Yeah, so the DBPR, so the Department of Business and Regulations, DBPR, we have an umbrella, right? They regulate a lot of industries. There's the professional side and the business side of things that regulate a lot of industries, licenses, and everything like that. Specifically, I am condominiums, timeshares, and mobile homes. I am the condominium ombudsman in that area. So my focus is on condominiums. Within DBPR, we do have the CTMH, which is condominiums, timeshares, and mobile homes. There is different departments within, such as the compliance department. The compliance department handles investigations related to the jurisdiction that I just went through. And again, sorry I wasn't sharing the screen earlier, but this is the jurisdiction for you guys as I was going through them. So any violation, a procedural violation of this, a complaint form may be submitted, and possibly a complaint can be opened after we review the complaint itself. And as we go on, there will be other duties and that CTMH and condominiums department does specifically. Like one is the ombudsman department, which is myself. We do election monitoring services. We also do a lot of office hours, one-on-one meetings. We can attend meetings for unit owners and things like that. And we'll dive into that within the presentation. So let's start off with the rights of a condominium unit owner themselves. And the most important right that I believe is the right to attend meetings. So as a unit owner, you have the right to attend meetings. This can be the annual meeting, a special assessment meeting. The board just wants to have a meeting. You, as an owner, have the right to attend the meetings. Now, there is some meetings that is closed doors, and we'll talk about that coming up. But as far as attending meetings, the association has to post a 48-hour notice for any board meeting that they want to do. So if the association decides, hey, we want to have a meeting, they have to notice that meeting and it has to be open to you guys as board members themselves. There are other meetings, just like the annual meeting, the budget meeting, a special assessment meeting, any rule adoption meeting, any meeting that involves finding or suspension for not following the rules of the association do require a 14-day notice. So those meetings, they're a little bit more important because you're talking about the annual budget, you're talking about the annual meeting of unit owners or a special assessment. Those require more notice. So it is a 14-day um, notice requirement for those types of meetings. But regular board meetings themselves only require a 48-hour notice. And in those meetings, again, you guys can attend those meetings the same way you can attend budget meetings, special assessment meetings. Um, itself. And in that you in these meetings themselves, you have to include the notice. You also have to include the agenda. And in that agenda, that would be the speaking topics of the meetings that's going to happen. And within those agenda items, you have a right to speak on those agenda topics yourselves. Unit owners may also will submit in writing to get these meetings notified via electronic means. So you do have to consent to get these meetings to you electronically. So that is one thing I like to point out that, the 48-hour notice, all they have to do is post it on the condominium property and they've properly noticed that meeting within 48 hours. So if you do want any electronic transmission, you do have to request that and provide consent to the association. So associations that are more than 10 units are now required to hold board meetings at least quarterly. So that means you need to have at least 4 board meetings per year. Um, And, at these board meetings, again, they can be 48-hour notices, but you are able to attend these meetings yourself. So you have a right to attend these meetings. You have a right to speak on designated agenda items. However, the association does have the right to make rules on how frequently you can ask questions, the duration of your questions, and the manner of your participation. So you also have the right to audio or video record these meetings. So you can go in there, you can video record, you can audio record. The association might have reasonable rules as far as you can't, disrupt anyone when recording, but you are allowed to record meetings. Now, uh, something that's been updated in 2025 is that video conferencing meetings are now a thing. So meetings of the boards, unit owner meetings, budget meetings, they can be conducted via video conferencing, which means you can use Zoom, you can use Teams, you can use any video conferencing platform that you wish to use. But you also have to have a physical location for those meetings themselves. So you can't just have it via Zoom and not have a physical location. So you can attend as unit owners either online, or you can also attend in person at a physical location. And we do have jurisdiction over those meetings, whether the board is doing these meetings quarterly as they're supposed to, whether there's a quorum being met, whether they're doing the proper voting procedures at these meetings. So we do have jurisdiction over those aspects of this of meetings. So again, rights of unit owners when it comes to meeting notices, if they are using a video conferencing. So let's say they want to do a meeting and they're going to do it via Zoom. So they're going to provide you a hyperlink. So a hyperlink is should take you to where the meeting's being held, either Zoom or Teams or any other platform they're using. They also have to include a conference telephone number. So, you can always call in. If you don't have internet, you can use a mobile device or a phone, a landline to call into that meeting. So that has to be provided in the hyperlink itself. You also have to have a physical location if you want to attend in person. So they have to also provide you with a physical location. If they provide you and says, "Hey, we're only doing this via Zoom," that is a potential violation that we definitely can take a look at. And we'll talk about that more, where you can send in allegations for a potential complaint. And the last thing they have to do is they have to make a statement indicating that this meeting will be held via video conferencing. So those are what's required when it comes to the noticing of a video conference meeting. They got to provide you the hyperlink. They got to provide a conference telephone number for people to call in if they don't have the internet access. They also have to provide a physical location for people that want to attend in person to attend. And they have to tell you in that they are going to use video conferencing in the meeting. Now, the meeting itself has to be recorded, so the meeting has to be recorded, and that recording is an official record that is available to be accessed. They have to use a sound system that you're able to hear all the conversations by the people that are online, and the people that are in person are able to hear what's going on in the video conferencing itself. Again, this becomes an official record of the association. So the recording of that video does become an official record of the association. And that meeting does have to be within 15 miles of the condominium property or within the same county. Um, Miami-Dade is a pretty big county, so it can be more than 15 miles, but as long as they're in the same county, they're not in violation of where that board meeting takes place. Now, same, there's unit owner meetings and then there's board meetings. So since we're talking about board meetings right now, I'm just going to focus on the board meetings here. So meetings are where your board holds the voting rights. So um, at board meetings themselves, if they do participate via video conferencing, that does count towards the quorum. So if they're voting, it counts as they're voting as they're physically present there. So the board can attend all via video conferencing at board meetings, and it does count towards the quorum. It does give them a right to vote as they are present. Did the screen come off, Alejandro? Is it still there? All right, we'll move forward. Unit owner meetings. So unit owner meetings themselves. So these are meetings where the vote is for unit owners, right? Your annual meeting is typically the only unit owner meeting that is required by statute. That is the only meeting that statute says that you have to hold for unit owners is the annual meeting. However, in some cases, if you get a quorum of unit owners, you can go ahead and host a unit owner meeting. So at unit owner meetings, same way, voting via video conferencing, you're allowed to do that. You can also vote via electronic means, and we'll talk about electronic voting systems later on, but also it counts towards the quorum. The only thing, though, is that if you're holding a unit owner meeting, you do need a quorum of the board members, and they do have to be physically present at the location. So for unit owner meetings, the board does have to be present, or at least a quorum of the board has to be present at the physical location. Unit owners can be online, but the board itself does need a quorum to be physically present as it relates to unit owner meetings. All right, so let's talk about the election, which kind of ties into your annual meeting because your annual meeting does have to be on the same date as your annual election. So, first thing, as far as when it comes to your annual election, is a 90-day notice of your voting rights being suspended. So, your voting rights may be suspended by the association due to you owing any monetary obligation. It also can be suspended if you've or have broken the association's rules and you haven't paid that monetary obligation to the association. However, the association does have to notify you 90 days before the election that your rights are suspended and you might not have a right to vote in this upcoming election. Now, that also correlates to your rights to run for the board itself. So if you do have any assessments that are pending and you haven't paid, you are ineligible to be a board member. So that ties into day number 40 right there, and we'll get to that. So 90 days before the election itself, the board does have to provide a notice of potentially your voting rights are being suspended. 60 days before the election is when you get the first notice of election. This is going to give you the date that the election should be taking place. It might have additional information in there, but the goal for this is to give you a date and time of the first notice of election. It also lets you know that hey, if you do intend to want to run for the board, it could provide information on how you submit your intent to run form, but it doesn't have to. It doesn't have to give you a form or anything like that if you intend to run. Simply in statute, it says, you just have to provide your intent to run to the board itself. The first notice, however, might set some parameters on how you do that. So, very important to review that first notice. Now, the 40th day is the due date for your intent to run. So 40 days before the election is when you have to submit your intent to run. That's when you have to make sure you have no outstanding assessments. Like I said, if you owe assessments to the association, it does make you an ineligible candidate for the election. So that's why that 90-day notice is also very important because it could tell you that, you might be suspended from voting and also suspended from being a candidate because you owe assessments. After that, you have the 35 days, which is the last day to submit your candidate information sheet. So your candidate information sheet is a single page, not front and back, just one page, any information you want people to know about you. So that way, it gets sent out with a second notice. That way you can promote yourself as the candidate. So that is due 35 days before the election. You don't have to do a candidate information sheet if you don't want to, but if you do a candidate information sheet, it's one page and it does get sent out with the second notice of the election. Now, the second notice of the election, it does give a 34 to 14-day window before the election. Usually they do 14 days before the election. That way they have enough time to get all the candidate information sheets ready and make sure everything is proper. But that notice does go out 34 to 14 days before the election. That notice is going to include any candidate information sheet that's been submitted. It's also going to include the agenda for the meeting, the notice of the annual meeting itself, and also your ballots. So your ballots and your secret ballots go out um, with the second notice of the election. And I think we had a question that was submitted beforehand when it comes to handling the election itself by the CAMs, so your property manager or your community association manager overseeing the election. So yeah, they can oversee the election. There isn't anything in the statute that prevents them from overseeing the election. The only thing that's prevented is when it comes to the committee that counts the ballots. They can't be related to any board members. They can't be on the board themselves. So that's the restrictions when it comes to that. But as far as the CAMs, the CAMs can be hired to run the election or oversee the election in this manner. All right, unit owners have the right to vote on association matters. So this is outside elections. You also have the right to vote on association matters, which for most times you're going to be using a proxy um, on these things. So either a general proxy. General proxy is you kind of generally are giving someone the right to vote on your behalf. Limited proxy is specific. It establishes your specific vote for that specific issue. So limited proxies have to be used when it comes to voting or reducing reserves. If your association is allowed to waive or reduce reserves, or depending on the reserve itself, you do have to get that vote from the unit owners. Any amendments to your governing documents, which means your declaration, your articles of incorporation, or your bylaws, does take a unit owner vote to be able to do that. Any other issues that unit owners have the vote, you really do have to check your governing documents to see what you can and can't vote on. Like a lot of the voting and the decisions when it comes to the business aspects of an association is with the board. The board has the vote there, but there are some specifics that you would have to check your governing documents for. Statute lays them out here, like waiving, reducing reserves, amending any articles of incorporation, declaration, or bylaws, also lowering your financial reporting at the end of the year. All that does need a unit owner vote to establish. Electronic voting is also available for unit owners. So unit owners may also do this via electronically, and you may opt out of electronic voting if you wish to not do so. But that is an option that electronic voting is permitted through an online voting system. However, you do have to adopt that by getting a 25% petition for electronic voting. And here is the electronic voting petition. So if 25% of unit owners petition for electronic voting, then the association has to go ahead and provide electronic voting for within that 180 days after your last annual meeting. So as long as it's within 180 days after the last annual meeting, you can petition for electronic voting system, which can be used both for elections, but it also can be used for voting on those requirements we just talked about, waiving reserves, lowering the financials, things like that can be done electronically. So after the board gets that petition, they have to adopt this within 21 days. All right. Unless the association adopted electronic voting, then so if they did adopt an electronic voting system, they don't have to have electronic voting via email. But if they haven't, then it is a requirement. So the association has to designate an email address to receive all your electronic transmitted ballots. This is something that was passed last year. So the association does have to have a designated email address where it can receive your ballots when it comes to the annual election. Unit owners can transfer a complete ballot to that email address no later than the scheduled date of that election itself. And the association has to count the completed ballots that are electronically transmitted to that designated email so that those ballots do count towards the election itself. So they can't be thrown out. Little bit more on electronic ballots themselves. These ballots are again submitted electronically to the association, and there's some information that has to be on this ballot. A space for the unit owner's unit has to be available there. A space for their name and their last name has to be there, and in all caps, you have to have the following statement that you're waiving the secrecy of your ballot is your choice. You do not have to waive the secrecy of your ballot in order to vote. By transmitting your complete ballot through email to the association, you waive the secrecy of your completed ballot. If you do not wish to waive your secrecy but wish to participate in the vote that is the subject of this ballot, please attend the in person meeting during which the matter will be voted on. So, your ballots are no longer secret if you do decide to submit it via email electronically. So that's one of the big things is elections are secret ballot. However, if you do vote via electronic email ballot, then that ballot is no longer a secret. So please keep that in mind. Um, I guess a shameful plug here. No, just kidding. As I said, the division, along with the compliance side, there is the ombudsman side of things. So the office of the ombudsman, we do have an election monitoring program. It does take 15% of the total voting interest or 6 unit owners, whichever is greater. Usually 15% is the greater number there, but you can petition your association to have an election monitor assigned to your election itself. So this is for condominium associations. So for condominium associations, if you get 15% of the voting interest to sign a petition, or 6 unit owners, whichever is greater, then the association will be appointed an election monitor by the state, by my office. All costs of this does go to the association. So all costs associated with the election monitoring process is paid by the association. If you want more information, please send us an email on ombudsman at myfloridalicence.com. Just a quick for the fee schedule, depending on how many units you have. So if you have 0 to 25 units, it is $250. 26 to 50 units, it is $325. 51 units to 99 units is $400. 100 to 150 is $150 plus $3 per unit, and anything over 151 units is going to be $125 plus an additional $250 per unit itself. So this again is an election monitoring program that the DBPR does offer. All right. We did have a question beforehand as it relates to unit owners' rights to official records. So, how far back does the association have to maintain these records? So, in a condominium, there's some records that are maintained indefinitely. That means they can never get rid of these records. But the records that aren't held indefinitely, 7 years is the good total. I mean, it depends on the record. But things like bids and also election materials, that's only held for 1 year. So there are different requirements, but any financial records themselves are 7 years. So financial records are 7 years that it has to be maintained. So you have a 7 year period that you can go back when it comes to the financial records of the association. There's other stuff that has to be maintained indefinitely, but there's things that are can be only maintained for 1 year, and you don't have to maintain it beyond that 1 year. So, unit owners' right to inspect official records. As unit owners, you have a right to inspect official records. That means you have a right to access the records. Specifically in statute, it says access records. It does not say you have a right to request copies, and they have to send you copies. So that's a there's also miscommunication or confusion there when it comes to that. But you have a right to access records. At the records request or the access to the records is where you can obtain copies for free. So you're allowed to make copies on your own with your portable device. You can take pictures. You can scan if you have a portable scanner. That is all allowed for you at the official records request themselves. Now, unit owners, if you do ask the association to provide you copies, they can charge a reasonable fee for those copies. All right. So you have a right to inspect records. And in our statute, there is a list of all the records that you can inspect. And I think we're gonna pop in there in the next slide to see that. And then one final thing, tenants, you don't have the same amount of access as unit owners. So tenants can only inspect the declaration, the bylaws, and the rules of the association. So, as I said, this is the complete list of records that you are able to ask to inspect. So, the governing documents, the rules, any approved minutes of the board meetings over the preceding 12 months, video recordings and hyperlinks of those videos. Like I said, if you use video conferencing, those video recordings, you have to record that, and that is available to be seen. Contracts or documents, bids that exceed $500. Those are kept for 1 year. As I said, bids are only kept for 1 year, but the contracts themselves should be kept for 7 years. Annual budget and any proposed budget that's kept for 7 years. Financial reports, monthly reports that is kept for 7 years. The educational certificates of each director or each member of the board. So, their educational certificates have to be maintained. All contracts, transactions between the association, any director, officer, corporation, or firm, any contracts or documents related to conflict of interest, any notice of board meetings, the agenda of the board meetings, notice of unit owner meetings, your current insurance policies, structural integrity reserve, so the study itself, also your milestone study, copies of permits, copies of affidavits. That is all official records that you can request. Again, you are requesting to inspect these records. So something that has changed recently within the last 4 years is now the requirement for the milestone inspection and also the structural integrity reserve inspection. So a milestone inspection is required for any condominium that is 3 floors or higher. These are habitable stories. This was has to be done, as you see, if the building turns 30. So if your building is 30 years old, then you will have to perform a milestone inspection, and then this has to be repeated every 10 years. And as unit owners, you have the right to be notified of the milestone inspection and the requirements of the inspection itself. Same thing with the structural integrity reserve study. Unit owners have the right to receive a copy of your structural integrity reserve study. um, it has to be received within 45 days after the association receives a complete SIRS report itself. So, and that's also an official record that the association maintains. This one they maintain for 15 years, actually. So, both the milestone and the SIRS are maintained for 15 years as official records. Unit owners' rights to financial reporting. So every year, your association is supposed to do a year-end financial report. This is something that cannot be waived. This is something that they can choose to just not do. It has to be provided. So you can receive a copy. You can actually receive a copy of the most recent financial report, or they can provide you notice that the copy is available if you do request them. So this has to be done no later than 180 days after the end of your fiscal year. So let's say your fiscal year is a calendar year, 180 days is about the end of June. So if you haven't gotten a financial report and your fiscal year is a calendar year, that might be a potential violation that we can look into. Um, so the association has to provide you with that financial report, or they have to provide you with notice that it's available upon request. If you do request the financial report, they have to provide it to you within 5 business days without charge. All right. So the association, hey, here's a copy that you can request the financial report. Okay, I want to request the financial report. Okay, I have 5 business days to give you the financial report upon your request. Also, the association does have to execute an affidavit as evidence that they either delivered you a copy of the most recent financial report, or that they at least provided a notice that it is available upon request. Another thing that is important for condominium associations is related to your budget. You do have to receive a copy of your annual budget and the proposed budget notice for that year. So every year there should be a proposed annual budget that you receive and a notice for the budget meeting. itself, that has to take place 14 days before your fiscal year ends. So again, if your fiscal year is a calendar year, that has to take place 14 days before the year ends. Please check your governing documents to see when is your fiscal year. But the annual budget meeting is a 14-day notice. So again, that is a 14-day notice that they have to mail it out to you. They have to mail you out the proposed annual budget itself with that mailing. In the budget itself, you should also receive the budget, and you should also receive the reserve schedule for the proposed annual budget. And if you receive a proposed substitute budget, this is for if the budget does exceed 115% of assessments from the preceding year, then the association does have to provide you with a substitute budget that the association develops. But there's a lot of caveat when it comes to that. You can't consider any of the SIRS assessments or any of the milestone assessments within that calculation itself. And of course, unit owners have the right to exclusive ownership and possession of their unit itself. You have the right to use the common elements, common areas, recreational facilities, and one of the most important things is you have the right to ask questions of your board and of your association. Now, statute is very specific on how you go by doing that, so you do have to ask these questions through certified mail. It is called a certified inquiry, a certified written inquiry that you send to the association. They do have 30 days, but they do have to provide you a response to your inquiries. So the association has 30 days to respond to your certified written inquiry. Now, if they do seek legal counsel, that does get extended to 60 days. So it is some time, but you do have a right to ask questions of your association. And the means to do that, as it's laid out in the statute, is through a certified written inquiry. Other things, you can participate in voluntary mediation. The DBPR's arbitration has mediators, paid mediators, volunteer mediators. If you're having issues with the association that you can move forward with, you can bring action for damages or injustice. And the last and final thing here is you can request your username and password. So if you don't have access to the website or to the portal, an online portal where these records are supposed to be kept, that is something you have a right to access as a unit owner, and the association has to maintain is their online portal where some records are kept. Not all those records, but some records are kept on that online portal. If you don't have that access, that is something you can request from the association and have to provide you access to that. I think before we jump into the responsibilities, we had some questions beforehand related to handling disagreements and violations when it comes to fines. So, it all depends on your governing documents when it comes to if you're breaking the rules of the association and they can find you for something, all depends on what's in your governing documents there. But if they are fining you for any violation of the rules, they do have to provide you with an opportunity for a hearing. If they haven't provided you an opportunity for a hearing, then that is something that the division can look into. But the one thing before they, give you that fine or put that fine on your account, they do have to offer you an opportunity for hearing. So that is something important to note. So, responsibilities of unit owners. So, what are your guys' responsibilities when it comes to living in an association or a condominium, right? So, I always say, a condominium, you're buying into a community. If no one wants to participate, and you have five people that are board members that are running the show, and because no one's participating, um, you know, how are we able to assist there? You guys have a responsibility to attend meetings to know what's going on in the community. You have a right to attend these meetings. You have a right to ask questions. You have a right to form committees to assist with board members when it comes to these things. So you can attend and participate unit owners meetings, either video conferencing or in person. You can also, be part of committees. committees, budget committees, things like that. You have a responsibility to your community. Voting, it's kind of hard to pass things if no one shows up to vote. um, I was examples of elections that the same board members continue to be on the board because no one runs for the board or no one votes at these elections themselves. That is a responsibility of unit owners, to vote on issues that are presenting itself. You want to lower reserves. If you can lower reserves, you want to change things. You want to do a material alteration or anything like that. That does require unit owners to vote. So that is required, of responsibility as unit owners participate in voting. Again, when it comes to elections, you can't have an election if you don't get at least 20% participation in voting. If you want to change your bylaws, let's say you have a really strict 1970 parking rule that the associate, when it was created, you can't change that unless people get together and vote on changing that. It does require unit owners to vote on when it comes to changing your declaration and your governing documents. And other votes. Another example is lowering your financial reporting. If you want to lower the financial reporting, it does take voting to do that from unit owners themselves. If not enough people cared to vote on it or show up to vote on it, then it can't be done. You have a responsibility to pay your assessments. The board the board has a responsibility to the association to maintain the property as it seems fit. Assessments is part of that. Assessments are to be paid quarterly or on a more frequent, sorry, a monthly or quarterly, or a more frequent basis. So you can only do monthly and quarterly when it comes to those assessments. You pay your shares to your common expenses. Right. This is a condominium. It is a shared. You share the common elements with all the other members. If a tree falls on the building's roof next door, you are also responsible for for any assessments related to that. You do live in a condominium. I get that a lot out in the field. It's like, why am I paying for the other buildings? You live in a condominium. It is shared common elements. You are responsible for the shared common elements of a condominium. The association does have the power to put a lien on the unit if there is any refusal to pay or behind in payments as it relates to assessments. So please take note of that. Again, you're responsible for sharing the common elements and the common areas with everyone, with their guests. That doesn't hinder or infringe the rights of other unit owners. You're also responsible to provide the association access to your unit. This is for them to maintain or repair any common elements that's needed to prevent any damages to the common elements or anything that's required in your declaration of condominiums. You can't make alterations to your unit unless if it has anything to do with the safety or soundness of those common elements. Most documents, it does outline, that you might have to get approval from the board before you can do something. So please, again, a responsibility, I would say, that maybe we don't have it here, is you have to know your governing documents. You have to know your rules of the association. Also, other responsibilities, you can serve on the board of directors. If someone recommends you for the board, you might want to say yes, but participate in the election. Can't tell you how many times we deal with in the public. It's like, okay, when's the last time you went to a board meeting? And you've never been to a board meeting. Um, you know, Condo living is you have to be active in condo living. Say, um, and here you go. You got, you are responsible for knowing and complying with statutes and other governing articles of your association, your declaration, your articles of incorporation, your bylaws, the rules and regulations of the association. Those are requirements and the responsibility of you as condo owners to at least, comply with them. A question that came up also beforehand, before we dive into this, is related to, I guess, how do we ensure elected directors are running the condominium and not the management company? So I will say, at the end of the day, your board of directors is the ones that hire the management company. It could be for a particular reason that they hire the management company, and the management company has particular job duties in their contracts. So again, they might have the election duty, they might have the records duty, but in the end, it is the board's ultimately responsible for hiring that management company itself. But a caveat is, as a board, this is volunteer work. This is not your. There's no income in this. This is, probably you come home from your job and you're on the board, or you're already retired and you're helping out on the board. So there might be a lot of them not knowing. They're not accountants, they're not engineers. So they do rely on the management companies as good faith to provide them answers. But in the end, it is the board's responsibility to follow the statute and making sure that the management company is all following along the statute itself with that. But nothing relatively prevents them from hiring the management company or for assigning duties to the management company. As we wrap up here, I just want to go over some helpful information. Hopefully, you guys found this helpful. But you can find more information on our website itself at myfloridalicense.com. You can go on here to verify licenses. You can go on here to file a complaint. We also have a new website called condos.myfloridalicense.com. This one's more on the education side. So there's a lot more resources as it relates to education. There's frequently asked questions. There's all our services. You can schedule a presentation if you want us to give a presentation to your association. You can file a complaint on that website as well. So that is condos.myfloridalicense.com. All these QR codes work, so you can check them out. If you want to scan the QR codes, it'll take you to those websites. Go to our next. So this is just if you are board members and you have the division does charge $4 condominium fees per unit. So if you need to pay any condominium fees to the division, you can do that online. That is the QR code for that. What we also have is our education events. Along with these, we do a lot of events in person. We go out, we have office hours in person, education events throughout the state. We have virtual events where if you like this presentation, we have other presentations on specific topics that dive a little bit deeper into records access, elections, financial issues, things like that. We have presentations for. You can check those out on our condominium calendar right there, the CTMH Education Events calendar. Check out everything that we have coming up. We usually plan out 2 months in advance. So you can plan accordingly to either attend in person or maybe to sit in one of our webinars themselves. And lastly, we have our customer contact. So if you do have any questions for us, I encourage you to reach out either online where you can submit your questions online. That's the QR code that'll take you there. But you can also schedule appointments to either meet with the compliance team. So you can meet with the compliance team, which is our investigators in person, or you can have virtual office hours with myself and my ombudsman team and my education team. So I can't guarantee that I'm going to be in all these virtual office hours, but I try my best to attend these and be there. And you can set up that appointment through that QR code right there. And you can set up an appointment to meet with the compliance team. So we do have an office in Doral, which is the closest office down, I think, in the area down there. But there's also an office in Fort Lauderdale as well. And then the last thing we have is the customer contact center. This is the 850-488-1122. Sort of like our call center. They will get you and take down the information and get you to the right location, and someone will reach out and provide assistance to you that way. And Alejandro, that is it for me. I don't know if you have anything else.
Hey, Cassio, thank you so much. I do not. I do see a lot of Q&A, which is great. But for that, I know that you will. What is this customer contact and this number good places? I will share this information in the thank you
Yeah.
for participating. today, for joining us today.
Of
Email.
course.
Once it's ready, I think if everybody can just send those questions there. Is there another place? Is this good?
Yeah, that's a great place to do it. They can send it online. It'll generate like an inquiry for us to follow up with. Another place, I don't know, is there a chat here? I can put it in the chat.
No. But you can share
No.
what do you want to share?
Yeah, so CTMH education at myfloridalicense.com is a great email. That is our education email. That is everyone, that's where we prioritize education questions. The reason we don't do open Q&A because you guys have very specific questions that you kind of need more than 2 minutes online virtually to answer these questions. So we do ask at ctmheducation at myfloridalicense.com. If you want, that is a great email to send over any questions you have.
Great. So again, what I'll do is once the recording is ready, I'm going to upload it to the commissioner's YouTube. I'll prepare the thank you for attending email, and I will include that information so everybody has that. And then
Awesome.
your questions that you've asked today in the Q&A section, send those to that website, and they'll try to address it, within a reasonable amount of time, I assume.
Yes, yes. Yeah, I know we handle some of the questions sent in beforehand. We do our best, but some questions take a little bit more time that we just don't have here to to answer them.
Yes, and for those that send in their questions in advance, thank you very much. Well, Cassio, thank you so much for breaking this down for us today. If you missed any of our past sessions, feel free to go to Commissioner Raquel Regalado's YouTube, and you'll find everything we've done there so far this year. Thank you again, Cassio.
Yeah, thank you. Thank you for having me.